Ann Applegate is our presenter for tonight, and really excited to have Ann join us in this new capacity as a consultant. I first met Ann when she was working with the Disability Law Center here in Anchorage as a disability rights attorney. And then she went on to the Governor's Council on Disabilities and Special Education, and now is working as a consultant in Alaska. Anne has children of her own. She has 9 other siblings, 60 nieces and nephews, who have all helped and shaped her view of the world. And her favorite quote from her mother that she shared with us was that children anywhere, the responsibility of adults everywhere, which is really true for us here at Stone Soup too. So we're so excited that she's with us. But this training series that we've been doing on transition is co-hosted, sponsored by the Alaska Down Syndrome Network. And Donna Davidson is here representing the network. And I think she also wanted to say a quick welcome before we got started.
Yeah, actually, Mary, I think you said pretty much everything, but the Down Syndrome Network is really happy to be supporting this, and we're really excited to have it available for everyone around the state that would like to join in, because in the past, it was in person only, and this is a wonderful opportunity. So if any of you attending tonight know other folks that might be interested in our series and that live anywhere in the state or the states, I suppose, also, do let them know, because it's easy to join in. So also, if you have any suggestions for topics, we are always open to suggestions and would welcome ideas.
Anna. Yeah, one of the upsides to COVID and having Zoom presentations is that they're available to folks statewide and making trainings a little more accessible.
I would like to say a thank you, of course, to Mary and to Donna, the Alaska Down Syndrome Network and Stone Soup Group, putting together this set of trainings for transitions into adulthood. It's a really, really great collaboration, and it's a great idea. It's something that it's a huge topic, and as a parent of a transitional youth or a young adult, there are so many balls that you are trying to keep in the air and juggle while you are also just doing your old life that was just having teenagers. So super important to have a lot of topics and break up all of the things you need to know into some incremental chewable bites. As Mary said, I'm the parent of 2 kids, and one of them has just flown the coop. So I am in the middle of that young adult zone myself. And for me, a lot of the questions that I've been working on within my work are the same questions that I have found myself contemplating with my youngest. And what it reminds me of is the universality of the parent experience, which is, or guardian or trusted adult, which is that you are trying to balance protection and safety and learning and growth and experience. And what I've really been thinking about a lot is that they're not different things, that the process of keeping our kids safe necessarily means that you expose them to incremental risk. You allow them the dignity to make bad decisions. You know, that zone of safe downside outcomes that they learn from and grow from. And it's the same no matter what your kid is doing or is like, their personality, their skills, their capacities. which is why I ended up changing, as you can see the slide in front of us. The title originally was really Guardianship and Supported Decision-Making Agreements, and focusing on those kind of two different tools in a continuum of tools. And I realized that what I wanted to say instead was, let's talk about planning for and supporting adult decision-making, and pull out that loaded kind of oppositional relationship between guardianship being protective and restrictive, and supported decision-making being much less restrictive and more about honoring individual choice, because I don't think that they are so opposed as all that. My much older child, I still help him make decisions, and we follow the same kind of pattern that we ended up describing for supporting decision making through that tool. It's the same process. It's the same process that I use. I recently had a big life change, and I had to have a financial plan, and beats the heck out of me. I mean, I'm a lawyer, and I spend a lot of time helping other people answer very, very specific questions to law. And I had no clue. I didn't know who to ask. I didn't know who I should trust. So the idea that that process is the same. Transitions look the same. It's just about moving different kinds of tools in and out, making that an individualized kind of process. So rather than just lecturing or preaching, I'm going to go ahead and give you some information here. Let me see if I can turn my, I need to move my, there we go. So we're going to talk about some tools for support and planning. And when I think of planning, I think of advanced planning. That's asking an IEP team to help you do this. That's talking to other professionals. If you are already on a waiver, then it's about talking to a care coordinator, talking with people who provide services, talking with folks who do respite, understanding what kind of goals for the future the person that you're planning with or for might have. And we also talk about tools for support. And for me, that's what those guardianship petition, that guardianship order, that's a tool for support. It's describing how you're going to support somebody else's decision-making process. So to list them all out here, let me get this. Guardianship, of course, most people know kind of something about that. And I imagine that some of you are here mostly to find out about that. And I have to confess that I'm not an attorney who does petitions for guardianship. I know about stuff basically. And a lot of the information I have is available publicly on the court's website, which is a great self-help page. But what I would want to do is make sure that you know that anything I say about the law today is general and shouldn't be taken as legal advice. All right, conservatorship. I kind of put these in order of, you want to wave, put this in order of more control to less control from somebody outside of the adult that needs or wants the help. Representative pays for Social Security benefits. Now, you may or may not know about this. If you've got an 18-year-old, you probably do. And it is a contract with the Social Security Administration that creates that relationship. Powers of attorney, those are less formal and also less restrictive, or there's less control given to another person, potentially. And advanced medical or healthcare directives. And then finally, supported decision-making agreements. And that's what we're going to talk about. Think of this as my roadmap slide. On the time there, make sure I'm not too far. So guardianship in Alaska, every state is different. There are some common ways of measuring and describing capacity or lack of capacity. There are some consequences across states that are similar, but every state has different laws. So that's an important thing to know. Of course, guardianship requires a court process. It requires a petition and a petitioner to start it, because essentially You're taking away someone's rights and giving them to someone else. And when that happens, we give people notice and opportunity to be heard. They get to have a process that's guaranteed by law. It involves lawyers, a court visitor, and hearings and findings by a judge, and an order that is enforced by the mechanism of the state, right? It is a court oversight order that describes what's going to happen in the future. It can be a thorough process, or it can be not so thorough. I have a dear friend whose court visitor never spoke to him. I know it someone else where there was a no dispute, and so the final hearing took 10 minutes. And in that 10 minutes, someone lost complete authority over all of their decision making. So sometimes I think there are some really great court visitors who are thorough, and they make sure they interview everybody that can be relevant, and they put together a report that the court can really rely on. But I think there are also, just like in every other field, there are people who cut corners. Mediation is available if there's a conflict, if there's an objection, if the court visitor feels like it's not that there should be brakes put on, then there can be mediation available, and that's through the court system. And of course, if guardianship is awarded, there is a training requirement, there's monitoring, there's reporting that has to be done by the guardian, and keeping accounting, making sure that they satisfy fiduciary responsibilities. That means you're really looking after somebody else's property and for their interest, making sure things are insured. And there's also periodic reviews. And of course, in statute, there is best practices guidance, and more you're seeing that courts are including that as part of their review. All right. So the judge in a hearing on guardianship decides legal capacity as a kind of a threshold issue. And what's important to know about that decision or that consideration is that the judge is looking at capacity only within the time of the court case. They're really just looking at a snapshot of a life, really. So they're not looking at a trajectory of skills that are growing or that are decreasing, or they're not, the judge is not trying to figure out if a year from now this might look different. And for an 18, 19, 20-year-old, that can be a pretty significant time of growth, particularly if the way the family functions is that there is just greater independence because of the way the young person is moving out into maybe a world that's got other providers in it. They have different services, whatever it is. The judge is really looking at the person as an organism almost. They're looking at a doctor's opinion, standardized tests, a court visitor's report, and any kind of witness testimony. But if there's no objection or opposition by a potential ward, that process is very simplified. Now, the other thing that a judge doesn't look at when they're looking at legal capacity, it will be part of the court visitor's report, but when the judge is deciding whether or not someone has capacity to understand or get information or communicate their decisions, that judge is only looking at functionality. They don't look at support for making decisions, whether there are family members or friends or employers or mentors, or maybe even people within a spiritual or religious community that perform some sort of supportive or monitoring or even supported employment. The judge isn't looking at any of that for capacity. Also, doesn't look at the use of professional services to help with decisions, because there are a lot, really. They're not described that way, but you have, an independent plan for, or an individualized plan for employment, for example, an IPE. There's somebody there that's helping someone figure out what it is they want to do. But the judge isn't looking at that. They're not looking at care coordinators or doctors or property managers, for example, or legal advocates or service agencies. It's really just about kind of this functional analysis. An incapacitated person in Alaska is someone who has an impairment of the ability to receive and evaluate information or to communicate decisions. So someone who's just got an impairment, I mean, honestly, an impairment of the ability to communicate their decisions could meet this first part up here. But that impairment of that ability, it causes a lack of an ability to provide for the essential requirements for physical health or safety. That's the first part. And then the next part is going to focus on the essential requirements for physical health and safety. Without court-ordered assistance, sorry, that's a big part. So that the judge is saying, if there's an impairment of an ability that causes a lack of ability to provide the essential requirements, unless I order somebody to do it, then there's a problem here. Essential requirements for health and safety are these six: healthcare, food, shelter, clothing, personal hygiene, and protection. But there's a caveat, without which serious physical injury or illness is more likely than not to occur. Now, in law, when you see more likely than not, courts have said, well, that's a 51%. It's like a preponderance, more likely than not to occur. So it's not just any possibility of physical injury and not just injury or illness, it's serious. So we're talking about some serious, some big consequences, right? I think of these as being the cliff edge consequences, outcomes that people don't come back from. That's what capacity and lacking capacity is about. It's about not being able to maintain the essential requirements, without which there's some serious consequence. Now, if someone is found to lack capacity under that standard in Alaska, then this is what the guardian has authority to do. A full guardian of an incapacitated person has the same powers and duties respecting the ward that a parent has respecting an unemancipated minor. So what you should be thinking is, what power and duty do I have over a 10-year-old, over a 5-year-old? And that is the kind of power and duties that a parent has respecting with regard to an adult under guardianship. If you're looking at this now, remember, as I said before, there are the best practices guidance, which talk a lot about honoring decision-making ability, expanding capacity and skills for making decisions with independent support or independently with support, things like that. But with this, you can imagine that there are people who have guardians who, when they recognize that this is the level of authority that a guardian has over them, would feel a sense of loss of personhood, of adulthood. We have people who are wards report to us a sense of disengagement from one's life because your consequences are so small. You have so little authority to act within your own decision-making that you start to lose interest in outcomes or choices. One of the great pieces of data that it exists about supported decision-making agreements, which there are not a lot of, or there isn't a lot of data, is that people, even controlling for functionality, people with supported decision-making agreements are much more likely than they're typically, or they're commonly achieving peers, to have supported employment, which is an interesting piece of data. But here are some of the exceptions. Least restrictive abode, institutionalization without commitment proceedings, abortion, sterilization, removal of organs. These are things that a guardian can't do unless they go back to court and make a case for this being in the best interest. Withholding life-saving procedures, prohibiting voting, terminating parental rights, prohibiting marriage or divorce, and others. But I ask you to consider that if you can't, as a guardian, prohibit somebody from getting married or divorced, but because you have the same powers and duties as if they were an unemancipated minor, you can then, of course, control who it is they see and who it is they spend time with and where they live and what they do for fun. And if that's the case, then aren't you just way ahead of the steps, prohibiting them from meeting and becoming close to someone they might marry? So it's about kind of that almost pre-control. All right, another kind of guardianship is a limited guardianship. And I'm pulling some of these in because I think that what we want to be looking at, like I mentioned in the slide, or the first slide, is that we want to be thinking about tools for individualizing those plans for adulthood. What do we need? How do we start asking the question that brings us to the just right set of tools for anybody? So limited guardianships, I think, are one of those really useful tools. The powers and duties are less than that of a full guardian, and it's as stated in the order. So the order will say what the areas of limitation are and what kinds of authority, what degree of power, what degree of supervision. And then the idea that there are duties that go along with that, what kinds of obligations for making sure that someone's money doesn't get taken by somebody else, or that there are that someone who has difficulty with making decisions about work, for example, that could be part of a limited guardianship. If the adult is found to have capacity for some essential decisions, but not others, then this is the kind of tool you would use. Going back to my example about my financial plan, nobody has consistent ability or capacity to make decisions across all areas of their life. When I used to do these in person, I almost always am wearing black boots because I love black boots and I have way too many of them. And so I could point to them and say, so when I want to get another pair of black boots, I used to call my sister and say, okay, talk me down. Talk me past this particular aisle in the clothing store, and what that was, of course, kind of half in jest. But the idea is that I make good decisions in some parts of my life and not great decisions in other parts of my life, and we're all that way. But limited guardianship has the same core process as a full guardianship, because again, we're talking about that court order that's enforced by the state. It's the mechanism of the state that takes away some of the rights of one person and gives them to another. So there's the same court process. Conservatorship in Alaska, and it's not the same every place else, because some states actually flip them, and conservatorship is more like what we would call guardianship. But a conservatorship in Alaska is about a specific scope and subject matter. Again, it is a court order. It is a judge's decision, and there is the same process then that adheres to this finding and taking away of rights. But it is one thing to remember is that it's only changed by the court issuing a different order. So those orders stand until something else happens in a court. But it's regards financial matters. The authority to make decisions about property and money is taken away from the ward and given to the conservator. It's limited by its terms, meaning it can be specifically just for real estate and housing. It can be for finances and banking. It can even be with regard to a kind of a limited type of transaction. I've seen a conservatorship that was just for with regard to a family held piece of land, that it was really the only big asset that this man had. It was an intake through the Disability Law Center when I was there. And there was conflict in the family, and there had been a history of this one man who experienced a developmental disability being taken advantage of within the context of this property ownership. So he had a conservatorship just for any dealings with regard to that piece of land. All right, moving out of the formal court process, a delegation or a granting of authority by the court that is permanent and until the court decides otherwise, moving across sort of into the realm of informal, self-written, self-managed kinds of tools. POAs, powers of attorney, are super helpful for a few important reasons. First of all, they're not done through a court. They're not expensive. They're informal. They are notarized, so there's protection. A notary has to verify the signature of the person who is giving away their authority to another person in writing. That's what they essentially are. The authority is granted or given by the adult who wants some assistance or wants somebody else to take care of a particular kind of right that they have, or a duty that they're owed or that they're supposed to be giving to somebody else. It can also be taken away by that adult. So that is, from my perspective, is a positive thing, because what it means is people are they have continued interest in that decision because they're watching to make sure that somebody is doing it the way they asked them to do it. And so if not, they still have control over who is doing the action, who has the authority, and whether or not that role is going to continue. It's usually limited in time, expressly in the document, but it can also be durable. And a durable power of attorney is one that lasts until it's revoked. It's often limited in scope or subject matter, so it's easy to keep an eye on. If you are assisting an adult who wants to grant a power of attorney to somebody else, it's easy to help them, to support them, to make sure that power of attorney is not being abused. It allows an adult to get help, but keep control over whether that help continues, as I just said. And what's lovely is the Alaska Legal Services, under a grant from the state, created a booklet about powers of attorney and what they are under our statutes, how to draft one if you're going to draft your own, what are the necessary parts to it. And they also created a form. It's a template that allows you to check boxes. Yes, this is what I do want the power of attorney to be for, and this is what I don't want it to be for. Super important to have all that good information. And I think, you can go right to that website there and get it. There are different types of powers of attorney, as I said. You can have a general, broad, expansive power of attorney over property and the person. That is something that often people used to do when people went away for a long period of time before we had such ease of communication. When I was young and buying a house with my husband, he was gone on a trip to Siberia, the forests of Siberia, to do research. And before he left, he gave me a general power of attorney because he didn't know what would pop up, and we were trying to buy the house. And so I had all complete authority, but I felt kind of powerful, not just having control over my own life, but over the life of another human. Let's see. Yes, checkbox type, sometimes used when there's extended travel overseas. There we go. They can also be specific, such as an educational power of attorney. I don't know if anybody has done that yet with their young adult. If they have an IEP, an individualized educational program, the power of attorney over educational decision-making allows people to make decisions about special education in conjunction and in consultation with their student, but it allows families, adults, or parents to still have a seat at the table at the IEP and still be able to get confidential educational records. Super important transition checkbox item. At DLC, they can do it for you. You can go, they have a form already. So you can call them and do an intake, and your intake says, I just need an educational POA. And your student actually has to do it. They have to have turned 18 to have authority over that. If you are already in the process of getting a guardianship order, then you don't need to do it, because it would, the guardianship order would include educational decision-making too. But this is a great way of making sure that the day after they turn 18, you can still get their educational records. Business transactions, home purchases, they can be really specific, these powers of attorney. And the reason I bring them up like this, the specific ones, is because, again, I think it's a really great tool for carving out places where there's a kind of intermediate level of control and an intermediate level of support for an intermediate level of risk in an area where this young adult can try out their independence. I used to call it a slow roll to adulthood. And these kinds of specific powers of attorney are a really good way to individualize your specific students or your specific youth's transition tools, to make them, to give them the opportunity for greater independence and an opportunity to learn how to negotiate systems, businesses or education, or even medical decision making, if that's a good area for the person that you're thinking about as you're looking at these tools. They're just a really great way to give opportunity for learning, and also some controlled risk. If they fail, then there are other tools that can come into play and help mitigate whatever damages there are, like, honestly, an emergency petition for a limited guardianship with regard to that same area. All right, I've already kind of beaten that with a stick. Advanced healthcare directives. Let's see, where are we on our clock? 7:10. Oh, good. Advanced healthcare directives are another great area in Alaska, because we have a statute that defines what they are and what the form looks like. And then again, Alaska Legal Services got a grant, and they took care of this. So the first part is a power of attorney for healthcare decisions. This is one of the areas that gives parents the most nightmares, right? You've got, if you don't have a guardianship order, and you've decided you're not going to do that, and you are putting together different kinds of powers of attorney and so on, not being able to get medical records for your adult child that you feel needs support in making decisions is just one of the biggest worries, right? And should something happen and they are hospitalized and they can't communicate well with the caregivers around them, and you are locked out of that process because you don't have a guardianship order, is enough to drive people straight to a guardianship order, even if they believe that it's not the kind of tool that's best for their young adult. Well, advanced healthcare directives help with that because they allow for different levels of healthcare authority, decision-making authority. They also have a place for making clear what kinds of choices there are with regard to particular areas of healthcare, and then with if there's death with anatomical gifts. There's even a special place for mental health treatment on these forms. And there's a part where presumably a primary physician is somebody that's been treating the new adult for a while. And so they're going to know more information about their healthcare history and choices that the family has made back when the adult was not an adult. So super good tool again for individualizing those plans and also making sure that you've got them for implementation. You know, you have the authority that you need to help. And they are at that website. We are really cranking here. And also I'm looking at the chat box questions. I'm excited because I want to make sure that I give enough time for everybody to get their questions answered. Now, representative payees, this is a real hard thing in Alaska right now because they're enforcing part of the rule about who can be an institutional representative payee that they hadn't been enforcing for a long time. So there is a bit of a shortage right now. It's kind of a crisis, but as a tool, again, for individualizing a plan for transitions to adulthood and also for a new adult, it's a great option. Of course, a representative payee is somebody who's under contract with the Social Security Administration. And it's when the Social Security Administration finds that the person who's getting benefits will not be able to manage their benefits. Now, if somebody's already under a guardianship order, then that's for the federal government, that's considered a given. Then they lack capacity to make financial decisions, and so they need a representative payee. Usually, a guardian is kind of the de facto payee in that circumstance. But if there is not a guardianship order, and the Social Security Administration finds that somebody needs a payee, that payee is only has authority to manage Social Security benefits, to receive the benefits, payments, maintain a bank account, write checks, and control how much spending money the recipient gets out of those benefits. If there's incidental income from other sources, the rep payee does not have authority over those. So because SSI is for meeting basic needs, there's usually not a lot of incidental income outside of that. So it's actually a kind of a good relationship, again, to give people some authority over a small amount of spending money, because that's all that's left, right? And it can be that contract for the representative payee can be another way that there is kind of guardrails on spending, because their core purpose for those Social Security benefits is basic living needs. Okay, so supported decision-making agreements. This is what I am most educated in, and so hopefully I can answer your questions. But I don't know if any of you have had experience or have had any exposure to the concept before, but the idea behind supported decision-making is that everyone can make decisions, that everyone is able to communicate what it is they want and what kinds of support they need at wherever they are along a continuum of functionality. That I have a dear friend who communicates to the people that she knows and trusts in 2-word utterances, but they know from being around her how what her choices are, what her preferred options for the day are, and those are her important decisions, and they have value, and they are valid in and of themselves because they are hers. So her supported decision-making agreement may not look like mine, which, I had one. I have to redo it now because some of my supporters have shifted, but her agreement still includes the same parts. And those parts are, it is a written, signed, notarized agreement that lists her team of supporters. They are her family members and a couple of dear family friends. One was a longtime caregiver, and what roles they're going to have in her life. It describes how each person gives her support, who is offering her choices for the day, who is making sure that she has long-term choices about supported employment, for example. What kind of plans are they going to make that are going to give her the choices that she seems to be indicating she wants to do now? How are they going to make sure that she's got the kinds of resources that she needs to make that choice? That signed agreement, it describes how big decisions get made in light of somebody's chosen goals. It can refer to attached documents if needed, like powers of attorney, to make things smoother, like getting access to records if you're talking about educational decision-making. Or if there is a limited guardianship, that the document is in there as well to make sure that everybody knows what the powers, the authority is in the hands of that limited guardian. It can include authorizations for release of information, if that's an important part of what the team is providing to the person who has the supported decision-making agreement. That release of information could be important. Now, the important part that I started to allude to in the very beginning is that it is not an alternative to guardianship. It gets called that a lot, but it's not, especially in Alaska, because in Alaska, which is kind of unusual in the country, we've been singled out as being an example of how to write that law now going forward. But if there is a guardianship in place, the guardian approves and gives written consent to the existence of the supported decision-making agreement. The guardian's essentially saying, there is this team that wants to help my ward or the ward get good information in order to make decisions, communicate their choices to other people, helps them figure out even what the questions are that they need to ask, or whether there's a specific person who's going to be able to help them get their option done. That team, that's good. I agree. Guardianship is not in conflict with that. It's a best practice for guardianship. So I'm good with it and I'm going to sign my consent. It can be used, that supported decision-making agreement, with other tools for decision-making and even tools that grant authority. If you're going to individualize a plan and look at somebody as a whole collection of strengths in some areas for decision-making and needing skills for other areas of decision-making, the supported decision-making agreement can be the written instructions for all of that. It can capture what kinds of assistance somebody wants or needs in particular areas. And what we found, they are now throughout the country. There are, I think, like 11 states that have them. There are 20, when I left the Gov Council in May, I think there were 23 supported decision-making agreements in Alaska. And what we found nationally is that they actually are protecting against abuse and neglect. People are concerned because they don't have the oversight and the supervision and the control that exists in some of the court-ordered tools. And so there was always a concern that there would be abuse of people who didn't have that kind of structured supervision. But what is showing up in our state particularly is that us having a supporting team that's organized and that talks to each other, having a family plus 2 people, there are 2 siblings and a teacher, and one of them is a longtime friend of the family. I'm just thinking of one example. And there's a problem with employment, and the team comes together, and many sets of eyes and minds all trying to help someone make a good decision means that there is more eyes on. There's greater protection because there's actually more support in a team than there is in that one-to-one relationship just with a guardian. Greater community engagement increases visibility and accountability. There's a great story that gets told, and I don't know what state it's in, but a young man who used to meet with his supported decision-making team, and people would see him. His supported decision-making team happened to include 2 of the places that he used to go a lot. One was a donut shop and one was a gas station where he got his bike a tire pumped up with air. And he was biking back and forth almost every day. And then he didn't. He was not biking for 3 or 4 days. And his 2 team members called each other and said, "Hey, have you seen him?" Nope. So they went and checked, and very sad story, but his mother had passed. She was an actually much older mother, and had passed away in natural causes, and he didn't want to leave the house. So he hadn't told anybody, and he was there. It was, 2 days, 3 days. And because he had team members who were actively engaged and knew about details about his life, that didn't become a real tragedy. So increasing that visibility and accountability. The other thing, of course, is that advocacy for self improves because there's a constant opportunity to talk about decision-making, helping people, modeling what kinds of questions you would ask, modeling how to find the person who knows the answer. All of that becomes, it's like that natural learning opportunity that we used to talk about in school. And that inclusiveness that we have all worked so hard to make sure that students with disabilities have. And it creates that inclusive discussion about goals and how to get them. It's a natural kind of conversation in which advocacy and self-advocacy just grows. Of course, I hate to talk about this with parents because it makes me sad and scared thinking about what happens to my kids when I'm not here, but even more so if they are vulnerable. But a supported decision-making agreement, as I've described it, that has a description of what kinds of decisions are made in different ways and with different ability, it is a guide for future protection because it's a blueprint of a process. It memorializes the kind of decision-making that already happens in a family with an adult who experiences a developmental disability. You all know how it is you interact in a process of making a decision. You know who you pull in that answers your questions about what comes next. And a supported decision-making agreement, as I've described it, creates a structure for supported independence so that if something does happen to you, it's in writing. You know what your family does. So that SDMA, it memorializes what your family already does. Communication methods, decision-making preferences, who are the supporters now, who are the natural supporters up ahead. There's a place on the SDMA template for alternate supporters, for writing in the names of people who potentially could be alternates if something happened to the supporters or they drift away. It also creates an historical record of decision-making to guide if there's a guardianship change or there's a new guardian. If something like that becomes necessary, you want to make sure that if it's a public guardian, that there's a reference, there's a place where they can look quickly and easily and see what kinds of decision-making has gone on before. Because it's likely the transition to a public guardian often results in a more restrictive guardianship order and definitely a more restrictive relationship because they just don't know the adult like the people who loved that adult. All right, so here is, 2 minutes to go. I'm so pleased. Here is an example of the kinds of tools I mentioned earlier on when I listed the tools for planning and for implementing a transition to adulthood. And I said that there are other places to get information or where you end up having to go through this process already of figuring out what people's preferences are and goals for themselves are. It's an important part of supported decision-making to have that background information. And you as parents, you know that information, but lots of people who are involved in creating supported decision-making agreements, they don't have the same level of experience with your adult. And so I always advise them to pull in existing places where you already have information, planning information about a transition to adulthood. Again, if there's already an advanced healthcare directive, because they have specific language describing roles, it's a great place to look at how you would structure a supportive team for medical decision-making. If there's an informed consent with assistance if needed, then that's a great place. It's also a really good idea to have one of those anyway. It's another great tool to use for particular medical providers. Now, financial plans or conservatorships, if there's an order like that and you're just helping someone else, it's not your adult, that can be a really great place to look for information about decision-making, about preferences. You can have an order to limit authority to only specific property or accounts or even amounts. ABLE accounts are very useful because they're limited in how they can be spent. So they create a kind of account with guardrails. Same with credit cards and debit cards with guardrails right now. There are all kinds of great tools that are just been the last 3 or 4 years have been created that are anticipating that parents of adults who need support are going to want to use this kind of tool. Of course, shared accounts is another great thing. Those old accounts that were set up when women couldn't have control over any money in the family, right? They get a little pin money. Those accounts have been repurposed for adults who need support for making financial decisions and need support with banking. If you're talking about, again, transition age youth at school, IEP programs, those transition programs, plans that you're supposed to have, and they're supposed to detail kind of what you need to get done or what the school needs to get done in order to prepare someone for greater independence. Having the school work with your student on a supported decision-making agreement is a really good idea. I was a special education attorney for 8 years, and unfortunately, I had not yet discovered supported decision-making agreements when I represented families, but this would definitely be on my list. It is a great exercise, first of all. I just wrote a guide before, I used educators, I didn't write it, just before I left the council on how to use supported decision-making agreements for all kinds of goals, writing, self-regulation, plans for employment. They can be about socialization or social skills, working with a team. It should be one of those core contextual kinds of projects where you end up pulling in goals from other areas, but definitely really worth doing, I think. Plans of care, of course, they require person-centered planning. I think it would be a great idea to include transition planning as part of a goal. It could be a great plan of care goal. Powers of attorney, I can't remember why I put that one in there. Oh, just that, of course, as I said before, it's a great way to individualize the decision-making so that you've got some protection and also some opportunities for experiencing risk or experiencing independence in decision-making. That rep payee contract, again, I mentioned it a lot. I talked about it a lot before. And then one that I just casually mentioned, but that IPE, it's supposed to, under the code, it's got to be the person making an informed choice with support and assistance if needed. And this is a really great place to exercise that that structure for decision making. Like, what does it look like? What do you want to do? You take some vocational standardized tests and see what you're good at. What makes you feel good? Do you like being around animals? Do you like to work with people? Do you like to just stock stuff? Does it feel good to just put that row of product all there and make it look good? Do you want to be, do you want to drive a truck? All of those things are ways to go through the process of making a decision. So it's another kind of tool that could be added into an SDMA. It could also be a tool that gets used for writing that SDMA. And of course, you've got the limited guardianship. That's that backstop for high-risk decisions. Or if there's a decision that you thought was something within that wasn't going to pose an unreasonable risk, and it has, then you can do that emergency guardianship as well. That's a fast process, and it can turn things around. If there's been a contract entered into, one of the typical, no, not typical, one of the old stories out of the law is a young man who just had a guardianship order, who went and bought a car and drove it off the lot and crashed it immediately because he didn't actually know how to drive. And this is in Kenai, I don't know, 20 years ago, 25 years ago. And the parents, of course, and guardians said he didn't have the authority to contract to buy this vehicle. And the car sales company said, yeah, but we didn't know that. So we aren't bound by that. And the court came back and said, yes, you are. Just yes, you are. And even if it weren't easy to find out using court records, that even if it were a difficult process, we would still do it as a matter of public policy. So that kind of backstop can be necessary. All right, information resources. These are some of the additional ones that I wanted you to know about. This is the court self-help page for guardian and conservator. Great FAQs. And in the FAQs, embedded in each one is the information that you would need about specific details or the forms that you need. They explain the difference between all the different kinds of guardianship, why you would need one over the other. They also have a section on supported decision-making agreements and powers of attorney. Unfortunately, their SDMA section links to the pages that I created for the Governor's Council, and that the cyber attack on the Department of Health in May had removed it. So hopefully it'll be restored soon. It was a lot of work, and there's a lot of great Alaska specific information that isn't anyplace else. So that's the other drag. Hopefully it comes up. ASAGA, that's the Association of Guardianship Advocates. It is amazing. Their website is so good. And my favorite part is their calendar of events, because they have really great trainings. They also have information about best practices for guardians. They have information about what to expect from a court visitor, all kinds of other really good stuff. Alaska Legal Services has got a great section on under their family law. They have a section on learning resources about guardianship. And of course, the Disability Law Center has a guardianship booklet, and they recently added a supported decision-making agreements insert. And I say this as a plug for them because they have been writing them. There is a template in the law, in the statute, for HB 336. I don't know what the, I don't know if it's gotten its code section in the actual legal basis where you go in and you search it. Last year it hadn't done it yet. They hadn't put it in yet. But it in the statute, there is a template that's a fill-in kind of thing that you can do. If you understand somebody's preferences well, you can work with them about it, and have a discussion about who they believe their supporters should be. But boy, shortcut, go to DLC and say that you would like more information about a supported decision-making agreement, and they will help you do that. There are some private practitioners, I think, now that are doing it. It's actually I am doing them as well, but go to the free lawyer first. Find out if you can get their help. This is an interesting resource that I just refound today. It is from the perspective of senior citizens with a need for a supported decision-making agreement, older adults. But it's still got a lot of great information. You have to sign up for their I don't know, it's like a subscription resource, but it's free. It's through the National Center of State Courts with the assistance of the ABA Commission on Aging and the Law. But it is that's focused on finding that right fit, which is kind of what I've been talking about this whole time. I would describe it as individualization, which is, of course, is the gold standard of all we try to do for children and adults with disabilities, but also what we expect for ourselves as well. It's just universality and individualization are just the two two like legs that have us standing up. That's my analogy. I think that's it. Yes, questions. Ta-da. Whew. I hope that wasn't too much and too fast. It's 7:41. What do you think, Donna? Did I get it all in?
Oh, it was marvelous. I so wish we'd had that 20 years ago. My son was just starting the process.
Yeah. Yeah.
Excellent information. I wrote pages of notes.
Oh, good. Wonderful. I'm glad to hear it. It's good to have that positive feedback to start out, because I've got 14 questions in the chat. Mary, can you help me with it?
I'm not seeing a whole lot of questions in my chat. Are they sent to you specifically?
Oh, no, so they aren't.
It's just me. I just posted the links because it's one thing to see it on the screen.
Yes.
But you're not going to be able to click.
Yes. Thank you for doing that, John.
You are awesome. Thank you, John.
But Alessandra was asking more specifically as a special education teacher in a high school.
Yeah.
How can she best support her parents who are asking questions about what they need to do next?
You know, again, and I say this over and over again, but really it'll be different depending on the parents and the student and the question. Just like, you know, this, that's not an answer that you don't know. But the reason I bring that up is because if you're talking about a student, parents who are thinking about it and their student has just entered high school, you know, if you were talking about someone at that stage, the answer is, oh gosh, include decision goals in social emotional learning about increasing information gathering skills, looking at decision trees, and helping kids at that age are just starting to develop kind of the ability to do a kind of a yes, no, then what, and at varying levels of complexity, right? So at that age, I would be talking about, you know, offering repeat trials of two decisions and what are the consequences for each, and a consideration of outcomes. And there's great material on that, as I'm sure you probably already know this. I'm not telling you anything, but there are great resources for curriculum, for how to break down the steps of decision making. And that's the kind of thing I would say for a younger student. If people are bumping up against 18, then I would be looking at their transition plan, which at that point should be a couple years old, and retooling it and looking at it in the light of this shortened time frame that they have now. And first of all, there are check boxes that they just need to know about, and that is that, you know, that educational POA, making sure that that's ready to go as soon as the kid turns 18. But then looking at here's what I really want everybody to take home. There are these structures that exist for all of the reasons that structures exist. You know, guardianship's been around since Rome, and it was used to take power from other families by basically stealing their children. But that just exists because it's there. Don't start from what is available. Start from what should be and start from what could be. Ask, what does my student want? What does my student need to get there? I have a lovely mentor, Kathy Fitz. I'll just say her name out loud. Kathy Fitz uses this example of a young woman, and I did this training with her for 8 years, and I always love this example. She was talking about supported employment, and there's a young woman who couldn't drive. She didn't have the ability to balance. She had mobility problems because of balance. She had processing delays. She had difficulty with vision. She really, really wanted to be a truck driver. That was her goal for herself, for her employment. And so what her team did, this was back when, the person-centered planning teams were starting. I can't remember what it's called. But the team looked at and asked her and used ways of communicating that were yes, no, and teased out that what she really wanted, the reason she wanted to be a truck driver is because she really loved to be in the vehicle, sitting up high, and she wanted to feel the motor. It's like, oh, okay, those are doable. Those are doable parts of bringing her to her chosen outcome. And so they found ways to get her into a big old semi more than a few times. And she sat in that vehicle and they turned on the motor and she felt that power and that height. And then they met her goal, right? And so I guess, Alessandra, I would say, find out what the kid's goal is, find out what's in the way, see if there are creative ways in your school environment that you can bring options that are outside the box. Don't think about what is already there. Don't think that somebody's got to have a guardianship order. Think what they need is help with this decision. They need protection with that area of their life. They need 3 people to know about just what they're doing in this other part of their life, and then find the tools to make that so.